tips for ensuring privacy and avoiding lawsuits amid pervasive technology tracking. Big Brother has all the knowledge. He might be aware of the several ways you've tried to keep your assets concealed, safe or protected because of technology improvements. If you haven't already and you've been wondering how to safeguard your valuables, have a look at some of the resources listed here. Next, put them to use safeguarding your future, your family and yourself. Asset protection is not just necessary for the wealthy and well-known. We're all involved. Our entire lives, we have devoted ourselves to securing a stable and prosperous financial future. Then all of a sudden, something unexpected occurs. Your assets may be attached or garnished for a variety of reasons. Imagine having to file for bankruptcy, divorce, or to defend yourself in a legal dispute. Let's say you are involved in something that leads to legal action being taken against you. It might not even be your fault, like when your adolescent gets into a driving accident or someone falls in your garden and files a lawsuit that exceeds your insurance limits. The impacted party may pursue your assets in each of these situations. Asset protection shouldn't be a last-minute or temporary solution. If you are sued by an auto insurance company, contacted by a creditor, or served with a lawsuit, you may be protected by setting up an asset protection trust. However, if you had put it up well in advance, the courts would not see it favorably. Contributions to retirement plans and asset transfers must be handled well in advance of issues developing. It is less important to conceal assets and more important to place them in the appropriate legal vehicles that will safeguard them, even if a creditor finds out. Manage your businesses as distinct corporations. If your company is sued, the corporation shields you from lawsuits. Separate corporations shield each company division from litigation involving the others. For the best tax treatment and asset protection, keep your interests in LLCs. Maintain one LC for each of your rental properties if any of your assets are risky, i.e., could put you in legal hot water, such as a house you rent out. Safe assets can all be placed into the same LLC, including cash accounts and stock market investments. Place sizable liquid assets in an asset protection trust, ideally one based in the Cook Islands. The bank and investment accounts will be held by an offshore LLC that is owned by the Cook Islands Trust. Manage your businesses as distinct corporations. If your company is sued, the corporation shields you from lawsuits. Separate corporations shield each company division from litigation involving the others. For the best tax treatment and asset protection, keep your interests in LLCs. Maintain one LC for each of your rental properties if any of your assets are risky, i.e., could put you in legal hot water, such as a house you rent out. Safe assets can all be placed into the same LLC, including cash accounts and stock market investments. Place sizable liquid assets in an asset protection trust, ideally one based in the Cook Islands. The bank and investment accounts will be held by an offshore LLC that is owned by the Cook Islands Trust. Wyoming Individual Name Company. We can create a corporation in Wyoming with the same name as yours without ending it with Incorporated Corporation or Limited. Therefore, if the name Pat Smith is already taken in Wyoming and it is your name, we can use it for the corporation. You can deposit your checks into this business and open a bank account. It is not required to file a list of managers in New Mexico. At all. Consequently, no one has to be mentioned in the public records. Who is the owner? Who knows? Who is in charge of it? Both of our guesses are valid. In Nevis, it's much better. No individual's name is listed in the public domain, not the owner, no supervisor. Your legal protection against creditors and judgments is governed by both federal and state regulations. For assets held in such an entity, LLC statutes in practically every state offer respectable asset protection measures. Certain states have tenancy by the entirety statutes that protect assets held in this way in the event of a lawsuit against one spouse. A residential dwelling is shielded from seizure by the broad homestead exemption laws found in several jurisdictions. However, foreign asset protection nations like the Cook Islands and Nevis have by far the strongest legal systems. One of the strongest and safest legal tools for money protection that is currently available may be a trust. All assets must be fully transferred to a trust managed by an impartial trustee who operates in the beneficiary's best interest. The trust now owns the assets in an irrevocable trust. You no longer own them. Therefore, there is nothing to lose when you are sued. One worry is that a well-constructed trust can be so well protected that sometimes when a judge orders you to turn over the assets inside, even you are unable to enter. The good news is that your creditor cannot access it if you are unable to. Your money is secure and cannot be taken by outsiders, yet you can still access it. An irrevocable trust's assets may be used by you, your beneficiaries, or both. Additionally, it can be used to protect resources for the present and future needs of your kids. Trusts for asset protection are now legal in states like South Dakota, Delaware, Rhode Island, Nevada, and Alaska. Nevertheless, offshore trusts in far-off locations like the Cook Islands and the Caribbean have more asset protection power than they do. Some people believe that making financial investments in their companies will shield their assets from creditors and responsibility claims. Their assets could be in jeopardy if there is an issue with their firm. If they are the company's owners, they could be able to borrow money secured by account receivables and place it in an asset protection instrument, like an asset protection trust, which would prevent creditors from accessing ordinarily attainable assets. You might have thought about giving someone else ownership of your possessions. You may argue that it is more difficult for someone to steal your money since you no longer own the assets. However, this strategy is overruled by rules about fraudulent conveyance, sometimes known as fraudulent transfer. Transferring money to someone else exposes them to legal action to reclaim the funds you moved to protect yourself from creditors. It's not a good look to bring your parent's son or daughter up in court on Thanksgiving. Similarly, it may be dishonest to spend down your assets or give your house to a relative to be eligible for Medicaid, Medicare, college, or residence, if it is obvious that the only reason you are doing so is to qualify. Furthermore, a substantial amount of time is needed because the majority of this needs to be completed well in advance of the demand. Indeed. One way to incorporate assets and the business into an asset protection strategy is to form one or more limited partnerships LPs or limited liability corporations LLCs. An LLC is a type of business that offers its owners limited liability. Similar to a corporation, the owners of an LLC are shielded from liability unless they provide a personal guarantee. Take it a step further. LLCs established on the Caribbean island of Nevis have all the protections offered by the US for LLCs, plus the benefit of Nevis being an offshore asset protection jurisdiction. This implies that when you hold assets inside of a Nevis LLC, it will be extremely difficult for a disgruntled party to effectively gain a judgment there. It is a well-known truth that creditors and the courts will not intervene if you are unable to access your money. Depending on your state's regulations, a retirement account, whether it's company-sponsored or individual, can protect your funds and provide favorable tax benefits. Additionally, though not usually, your employer-sponsored retirement account may be protected from creditors and bankruptcy. Therefore, be sure to examine your state's exemptions. Federal law caps the protection of contributions and earnings in both regular and Roth IRAs against bankruptcy at $1 million, adjusted for inflation. However, every state is different. Certain protections apply to amounts carried over from qualifying plans, although depending on the state, these protections may only apply to bankruptcy or other judgments. Retirement assets are not taken into account when determining the anticipated family contribution EFC for college funding. All assets, however, outside of retirement accounts will be taken into consideration. It's simple to safeguard intellectual property IP that you believe has significant value. Just keep your concept a secret. But can you prove you came up with the idea first if someone else steals it? Did you take every precaution to keep the concept safe? Have you filed for a patent? If not, that concept might be appropriated by someone else. Refrain from copying, printing, faxing, emailing, or revealing your trade secrets in writing form with anyone to safeguard them against technology. To write and submit the patent application, think about working with a qualified patent attorney. If someone is violating your patent, you should take legal action right away. Waiting 10 years to sue someone for patent infringement will not help your case. Although the goal of patents is to protect the little guy, they may be expensive to defend, with the median cost of a patent lawsuit being approximately $5.5 million. After you have patented your idea, you might want to store it in an asset protection mechanism like a trust or LLC. In this day and age of perpetual litigation, when financial losses are possible, you must take precautions to safeguard yourself before you become a target for the dishonest attorneys who file these claims. Anyone who fears they could become the target of litigants or money-hungry solicitors must have a solid asset protection plan. Regretfully, instances have demonstrated that an individual's vulnerability to such attacks increases with their asset wealth. The first thing you should do is take steps to lessen your vulnerability to these folks. Paradoxically, this is one of those circumstances where it's advantageous to not have riches or to look to have it. Set up an asset protection trust for your liquid assets, operate your businesses as corporations, hold your investments in LLCs, give up some of your assets and entrust them to tested legal tools, and make sure you have planned ahead of time to avoid being taken advantage of by vultures. There are doable steps to take even in that case, because in the grand scheme of things, people who believe they stand to gain from their conduct file ugly lawsuits. Have you observed that dishonest solicitors and their clients seem to focus more on the wealthiest and most accomplished individuals? Who, after all, would take action if the financial rewards were indeed insufficient to justify their efforts? And what's your assignment? To remain concealed from curious onlookers as you watch them work from a distance. This is the first piece of advice on asset protection. Run your companies as LLCs and corporations. Please do not operate your company as a sole proprietorship or partnership. It's similar to defending yourself with tissue paper during a knife fight. Use an LLC or company to conduct business. Your LLC or corporation serves as a wall made of brick. Your personal assets are on the other side of that wall and are protected from business responsibility when your firm is sued. It is imperative that your firm be set up correctly. That is the exact language that the Articles of Formation should contain. Regardless of where you truly live, you must select the correct state or nation. A good draft of the operating agreement or bylaws is required. For a corporation, the annual and first minutes must be completed correctly. Certificates of stock co-membership must be completed. When our team creates a corporation for you, the company kits they supply include simple to complete paperwork that even a sixth grader can grasp. You also get all the assistance and support you require. Try to have multiple firms if you are a multi-business owner. Avoid allowing a lawsuit against one company to bring the others to a standstill. LLCs and corporations are inexpensive. Suits cost a lot of money. Invest in a single or more LLCs. Standard LLC law has measures that shield the business and its assets against seizure in the event of a lawsuit. To benefit from this protection, an LLC must have multiple owners in the majority of states. Only a few states, Nevada, Wyoming, and Delaware, for example, statutorily safeguard the membership in a single-member LLC and its assets as of this writing. 96% of all lawsuits filed worldwide, 80% of lawyers worldwide, and 4.25% of the world's population all reside in the US. The majority of business people merely stand there in the rain, believing that nothing can be done about it. How about running your firm as an offshore company? The LLC on the island of Nevis in the Caribbean has some of the most robust LLC asset protection rules worldwide. A $100,000 bond must be posted with the courts before you can sue a member of Nevis LLC for his interest in the firm in Nevis. They cannot take the LLC away from you or access the assets therein in the unusual event that they receive a charge order against your stake in the LLC. In the United States, a judgment can follow you for 20 years. The charge order against your LLC expires in 3 years in Nevis. Even a single-owner LLC is protected by this. A Nevis LLC can be used by anyone, including a U.S. citizen, to run their U.S. firm. All that needs to be done for the company to conduct business in the state in which it is located is for it to be foreign qualified. That functions in almost every nation. A Nevis LLC may be used to conduct business in the UK, Ireland, Australia, Brazil, or India. Holding offshore investment assets is the Nevis LLC's most popular application. Do you want your funds to be safe from harm by an offshore bank? Create an offshore bank account and Nevis LLC to protect your money from avaricious local attorneys. To reach the number above, simply press the appropriate buttons on your phone. The Cook Islands Asset Protection Trust is the world's most powerful asset protection tool. The trust needs to be properly drafted. In the Cook Islands, a trustee is required. It must be founded by a knowledgeable and experienced organization. This company has created more than 1,400 trusts as of right now. Nobody who has created a trust of this kind under our direction has ever experienced money loss from investments made in one. Liquid assets kept in a nation that does not recognize foreign judgments against the trust are best protected by this offshore trust arrangement. Thus, we open accounts in countries that are friendly to debtors, such as Belize, Nevis, Switzerland, and the Cook Islands. Global Finance lists the 50 safest banks in the world on a regular basis. There is a widespread misconception in the US that the only secure banks in the world are found there. False. There are just 4 US banks on the list as of this writing. That's right, just 4. On the list they are ranked 34, 45, 47, and 48. Which financial institutions? Since all 4 of them are small farming banks, the majority of people haven't heard of any of them. Imagine that you are a kind, honest person living on an island. The issue is that you don't have a lot of natural resources to sell. The manufacturing industry isn't flourishing in your country. In a place with few tourists, the approach to economic development revolves around creating robust legal frameworks that protect the assets of the wealthy from legal challenges. This strategy involves establishing the world's most comprehensive asset protection laws, thereby attracting wealthy individuals and their assets to the region. Upholding a stellar reputation becomes paramount, as it is a crucial source of wealth and stability for the nation. Without such a reputation, the local population could face economic hardship. To ensure this reputation remains untarnished, a stringent regulatory board is set up to monitor trustees meticulously, akin to a colony of bees guarding their hive. This board's role is to enforce rigorous standards and provide constant oversight. Trustees in the Cook Islands must undergo thorough background checks to obtain their licenses, ensuring they are highly qualified and trustworthy. Additionally, insurance companies are required to underwrite these trustees, adding another layer of security and confidence in the system. This multifaceted approach ensures that the nation's economic stability is maintained through the diligent protection of assets, attracting more wealth and consequently benefiting the local population. Stay tuned for more information.